Good morning. I am Berta Lopera, and I am the Executive Director and the Director of the Legal Clinic at Seniors First BC. And I have been in my post since July 16 this year. There is so much to say about this topic, but I am going to be very brief because time is of the essence. To be honest, it is bittersweet to be here. I am happy because of you, wonderful people that care about the most vulnerable in our society, and in this case, seniors. I am happy, extremely happy, because we are broadcasting for the first time from our office, and it is more affordable, and it means that in the future we are going to be able to connect with more people and with more communities and more seniors directly, and in fact with the whole province, because this organization is a province-wide organization, and the topic is not, sadly, is not province-wide. It is countrywide, worldwide. I am happy because there are participants from everywhere in this province, from the northern region, Vancouver Island, the interior of British Columbia, and the lower mainland, and basically from all over the province. The sad part, to be honest, is having to talk about this matter. But it is a fact, and it is real, and unfortunately it happens to the most vulnerable, and it happens to seniors. I am sure that everyone participating in this discussion knows at least one person who has been abused. Perhaps a client, a friend, a member of the community, a parent, an older sibling, an aunt, an uncle. And it hurts, doesn't it? Thank you for being here. Thank you, you first responders that are there to respond, to support, and to educate. Thank you from the bottom of my heart.
Thank you, Berta. My name is Genevieve Smith, and I am the manager of the Seniors Abuse and Information Line and the Victim Services Program at Seniors First BC. The panel is speaking from the Office of the Seniors First BC Society in Vancouver. I would like to begin by acknowledging that the land on which we gather is the unceded territory of the Coast Salish peoples, including the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. We would also like to acknowledge the Ministry of Justice for the funding for this webinar. So the goal for today is to provide information about who to reach out to when assisting an older adult who is being abused, neglected, or is self-neglecting. We will be using the decision tree as a framework for the presentation. The decision tree was emailed to you as an attachment, and hopefully you've made a copy for reference. I now want to hand over to Alison to provide us a brief description of the decision tree.
Good morning, everyone. So the decision tree that we're referring to looks like this, and hopefully people do have a copy of it. If for some reason you don't, it is available on the Public Guardian and Trustee website. trustee.bc.ca under reports and publications. So I just was wanting to say a little bit about it because I think it actually does give us not only a framework for our panel today, but also a framework for figuring out who to call when. And that really was the impetus behind it. So it is a decision tree for making effective referrals. One thing I think that we know about situations of abuse or neglect is that if people get bounced around too many times, not connected with someone who can assist them the first or second or third, in the first, second or third call, that they may give up hope. And so that's really what we were trying to, and the developers of the decision tree were trying to accomplish. It was originally created to benefit financial institutions who didn't and don't always know who to call. But I think it quickly became evident that it's a tool that can be helpful for anybody in the province that encounters older adults and other people who may be vulnerable to abuse and neglect. It was developed by it was a collaborative initiative between my colleague here, Leanne Lange from Fraser Health, representing kind of the designated agency perspective that you'll be hearing more about, the RCMP E-Division, and staff in my office at the Public Guardian and Trustee. The reason that I think it is such an important tool is because it really does summarize the response to abuse, neglect, and self-neglect of vulnerable adults. And although I know we're being hosted here by Seniors First and Seniors Organization, it really is intended to reflect the response to vulnerable adults aged 19 years of age and older in the province. And so I just wanted to give a really quick summary of it. I guess the other thing I'd like to say about it is that it's not only based on the adult guardianship legislation and some very specific provisions within the abuse and neglect provisions, the Public Guardian and Trustee Act, and the Criminal Code for police, but I think guiding everybody that's involved in the response in the province are the guiding principles that are inherent in the decision tree. And those guiding principles are that we all have the right to make our own decisions as long as we don't hurt anybody else and as long as we're mentally capable. And that means that, and it's really hard for others to watch, that people who are experiencing abuse, neglect, or self-neglect might not choose to leave those circumstances, and they get to make that decision. And that, I think, is one of the hardest things for all of us because we care about people. So that people have the right to self-determine, and they are presumed to be mentally capable until the contrary is demonstrated. If people need assistance, that all of us are working towards providing the least intrusive, most effective form of support, and actually going to court to remove people's ability to make their own decisions and have someone do that for them is really the last thing that we want to be doing. So you're going to hear a lot more about principles throughout this talk. So there's really 3 or 4 questions in the decision tree that would help narrow down who to call. And you're going to hear from folks who can talk about why you might call them. So the first question, if you look at the top left, is the adult in immediate danger of physical harm? If the answer is yes, that would be a call to 911. So you'll notice the no answers run down the left-hand side of the page. So if it's not an emergency, but many of these circumstances still very concerning, then the next question is the adult able to seek assistance? And that is a really important question based on the Adult Guardianship Act, because people who are abused and neglected and unable to seek support and assistance on their own because they are being restrained, like say locked in a room, or they have a physical disability that's preventing them from removing themselves from a situation, or they have something happening cognitively that is impacting their ability to understand the danger they're in, that is when a designated agency would have a role to get involved, a very clear role. So so the question, is the adult able to seek assistance? If the answer is yes, so there's none of those concerns, then there are a whole bunch of agencies on the right-hand side middle of the decision tree that can be of assistance. And you're going to hear from many of them from the victim service perspective, the Senior Abuse Information Line, and also other agencies, including Victim Link. And you'll notice that there is a spot that says local agency and there's a blank. And that's because the BC Association of Community Response Networks actually keeps an up-to-date record of local agency numbers that people can call depending on the kind of assistance that they need. And I think that it's important to know that the Community Response Network movement is on this one-pager as well, because part of the response in the province is trying to work towards prevention so that none of these situations come up in the first place, right? So that's why they're listed here. So is the adult able to seek assistance? Yes. Then they can call any of the numbers that you're going to hear about and any that are listed on the CRN website. But if there's a doubt about that, or if the answer is no, I'm really concerned, this person, they seem quite disoriented, quite confused, for whatever reason, then the next question is the abuse, neglect, or self-neglect that they seem to be experiencing primarily of a financial nature, where their assets at risk, or is it more non-financial, where there's concerns more about their own personal physical safety? So if it is mostly financial that you're hearing about, and that's the part of the story then that could be a referral to the public guardian and trustee. And if it's more, the information you have is more that and maybe physical and concerns as well, then that could be a referral to the designated agency. The two-way arrow on the bottom right really does suggest the reality, which is the public guardian and trustee and designated agencies work very closely together in this province. So there's no wrong number to call. It's just how do we get people to the best number in as few tries as possible. The back of the decision tree has a summary of a lot of what you'll hear today about the role of the PGT, the police, and designated agencies. And so that's what I thought might be helpful for people to know before we get started.
Great. Thank you very much, Alison. So I'd like to introduce our panelists. We have Nagat Afsar. Nagat works in the Legal Advocacy Program of Seniors First BC. The Legal Advocacy Program is province-wide and provides services to older adults 55 and over on residential tenancy disputes, including representing seniors at hearings and assisting seniors to remove unauthorized people from their rental units, transition of older adults from independent living to care homes, access to CPP, OAS, and GIS, and other benefits, and debt issues. Nagat also represents clients before different provincial and federal tribunals. Nagat was a practicing lawyer for 15 years in a foreign common law jurisdiction. She received Britannia Chevening Scholarship to do her LLM from England and was also the recipient of a Fulbright Scholarship to complete her master's degree in urban and regional planning from the United States. Nagat is now completing the legal requirements to become a lawyer in Canada. And then we have Sarah Khan. Sarah provides legal advice and representation to older adults through the Seniors First BC Elder Law Clinic program. Prior to joining Seniors First BC, Sarah worked at a social justice law firm where she developed and litigated constitutional, administrative law, and human rights cases and law reform initiatives, primarily on issues involving income assistance, disability benefits, employment standards, access to legal aid, and access to affordable residential electricity. Sarah received her law degree from the University of Victoria. Then we have Leanne Lange. Leanne has been employed by Fraser Health as the clinical specialist, adult abuse and neglect for 11 years. She has a master's degree in public administration from the University of Manitoba. In this role, she leads Fraser Health's response to adult protection-related issues across the region. She provides consultation and support to staff working in hospitals, community programs, and residential care who respond to situations of abuse and neglect of vulnerable adults. She also develops resources and provides education to staff. Finally, she assists to advocate for solutions to system-level issues which affect vulnerable adults. Leanne is also responsible for managing the Certificate of Incapability process in Fraser Health. And now to Alison Leaney. Alison Leaney is a registered social worker and the Provincial Coordinator, Vulnerable Adults Community Response in Services to Adults at the Public Guardian and Trustee of BC, where she has spent 23 years in implementation of BC's adult guardianship legislation. Alison chairs the BC Association of Social Workers Seniors Community of Practice. She is a former chair of the Canadian Network for the Prevention of Elder Abuse and former executive director of the BC Association of Community Response Networks. Her practice as a frontline social worker has been in the medical, corrections, domestic violence, hospice, bereavement support, and pastoral care fields. She has worked locally, provincially, and nationally. Most recently, she was a part-time contractor hired to coordinate the Sunshine Coast Seniors Planning Table. Alison was recently awarded the Queen's Diamond Jubilee Medal for her work to create a coordinated response to adult abuse and neglect in BC and Canada, and was a finalist for the Premier's Legacy Award for the same work in 2010. Alison also recently has been appointed to the National Seniors Council. So I'm going to move to Marnie Steckley, and Marnie's going to introduce herself, and then if you could just begin with your presentation once you've introduced yourself. Thank you.
So I'm Marnie, and I actually work for Family Services of Greater Vancouver, which is a nonprofit agency, and we are partnered with the Vancouver Police Department. So I'm actually housed inside the Vancouver Police Department, and myself and my police partner provide follow-up and support in high-risk cases of abuse of older adults. And so I've been in that role for a very long time, probably 10 or 12 years now, and as well as doing kind of client direct service work. I provide a lot of education to police officers in acute care settings, community agencies, the court system, primarily on the cases that I see, which are the sort of more high lethality cases of abuse of older adults. Yeah, so that's me. Just important to say, because I don't actually work for the police department. And one of the reasons that that's very important is that my team, so the elder abuse team of 2, we are housed inside the domestic violence and criminal harassment unit. And the reason that we have a partnership outside of with a nonprofit is in order that I can provide actually confidential support services to people who have been victimized. And what we have found is the reason for that is that sometimes it's difficult for people to disclose everything that's happening to police and to the court system because they have to act on that information, whereas I can work with clients to try to reduce harm without always having to involve police or the court system or other systems. So I am not, in my job, I am not a designated agency. I don't fall under the mandate of the adult guardianship legislation. So I provide counseling services for sometimes up to 2, 3, 4 years to my clients. So, but I'm going to talk for a few minutes more about my team and what we do. But I think I first wanted to address kind of the calling 911, sort of the first step in the decision tree. Here it talks about the adult being in immediate danger. So I think the important thing to remember about that is that as service providers or as family members or support people or whatever, we don't have to be the ones that decide that a crime has been committed. I think that's important, right? So something is wrong. Maybe we're afraid, the person is afraid, and that the police can sort out for themselves what the various options are around police intervention when they get there. And sometimes what you'll find is you call into 911, and even the operator that you talk to, the comm op, they will talk to you, ask you questions, and help ascertain, is this a situation where we need to send a patrol car really quickly? Or is this a situation which they can downgrade to a kind of a non-emergency call, which is actually a different number? So they would direct that person to that other phone number, and they can call back and get some guidance around that. So So I think that's important, that we don't have to determine ourselves, is this a crime or not? It's important for the police system to do that part of that. And the other thing is that there's a variety of ways in which police attend to and support situations of abuse of older adults. One way is a call called Check the Wellbeing. So that's a situation where maybe a family member is very concerned for their parent or aunt or friend or whoever, but they don't know what's happening, right? So they feel like something is wrong, but they don't know what it is, or sometimes they're missing, or sometimes they're worried that someone that's dangerous could be going over there or is there with them now. And so you can call in and ask for a check the well-being, which means the police simply go, make sure they're doing okay, make sure that older adult is there and is safe. So that's a call that we encourage people to use, and we encourage older adults themselves to use that. So something's wrong, I feel nervous, I feel worried about what's going to happen here, things are escalating, I'm uncomfortable. You can call in and ask for help from the police to make sure you're okay. So sometimes that would be called a keep the peace, so they're not coming because they're investigating a specific crime, they're coming to help you because you're afraid. So we always encourage seniors, for anybody honestly for that matter, to call if they're in a situation where they're afraid. The other thing I think that I've noticed in my work that's important around calling 911, many of my clients feel very reluctant to call 911. And so they don't want to speak into the phone. They feel nervous about what to say. They feel nervous talking about the situation at all. However, they are afraid. So you can call into 911 and actually not say anything. And as long as you leave the line open, then, right, so you just don't hang it up. So we tell them to call 911 and just leave the phone there. That can be if they're in a dangerous situation and they don't want to say in front of the perpetrator, I need the police to come, because that can be quite dangerous for them to do that, actually, because the police take a few minutes to get there. But it can also just make them feel, especially if language is a barrier, right? So what will happen then is police will come right away if the line is left open in that way. The other thing that we sometimes use, and I'm not sure this is actually supposed to be advertised, but occasionally clients of mine have Lifeline. And then we make an arrangement with Lifeline that the Lifeline might be pressed for different reasons, right? So if the person is afraid, that they may use the Lifeline to get the police to come. So that's where people are very reluctant to make that call. So and the other thing is, it's not just if you're in immediate physical danger. Like if you were assaulted last week or yesterday or 6 months ago, or sexually assaulted or stolen from, you can call into 911. They'll downgrade that to a non-emergency call, and someone will come out and take that information from you and see what the options are there. So it's not just for immediate danger. And I wanted to talk about, keep the peace is also a role that police officers take when accompanying mostly health authority staff out to do investigations. So let's say there's a situation where an adult child is very aggressive, has a history of violence, doesn't want to open the door to health staff in order for them to see how that older adult's doing. Or they've been directly threatening to other staff. Police officers, generally patrol officers, can be called to go and accompany them to make that visit. So that would be stand by or keep the peace. So that's another way in which police officers are used in these kinds of investigations. With regard to crimes, so there is no crime in the criminal code called elder abuse. Right, so it's just like any of us. If a crime was committed against us, it might be an assault, it might be a theft, it might be a sexual assault, it might be criminal harassment. Those are the charges that are used in these cases, and they proceed like any other case. So what would happen is the patrol officers would collect information and evidence, generally asking for statements from people. And in the court system and in the criminal justice system, we don't use the term capable. We don't use that concept of capability, but we do use a concept of credibility, which is a little bit different. And all that means is that the person is able to say sort of honestly what happened to them, and the only dilemma with that is sometimes these cases can take a long time to go to court. And so sometimes memory impairment will be difficult. Although that person can review their police report at the time that they do the interview later or go to court. So I just wanted to clarify that we don't, for example, in the police system or in the Crown Council, they don't ask for the same type of capability assessments. That's not part of the criminal system. Sometimes, of course, those capability assessments are relevant to a case, but we don't use them as a way of proceeding through the criminal court system. So I wanted to make a short comment about theft by power of attorney. We get obviously a lot of financial crime. My team does not deal with financial crime. So my team of 2, we deal with the sort of higher risk assaults, sexual assaults, physical safety kind of situations. There is a financial crime section. The follow-up units generally, as probably most people know, they take them after they're about $1 million, $500,000, $1.5 million. That's when they get forward to a special unit. But patrol officers will take those reports of theft. Oftentimes, I think what happens is if a person gives their bank card to somebody or gives them their PIN number and they go use it and clean out their bank account, that's very challenging for the criminal system to be able to proceed with charges there. What we do sometimes see is those patterns, which we see all the time, parents giving their adult children money continuously, is that they're actually afraid. They're afraid to say no. And so while we cannot sometimes proceed with a theft charge, and we certainly can't get their money back in our system, what we can do is look at some kind of protective conditions. And so that is when we might proceed with something called a peace bond, which is part of it's a criminal code charge, and it's a protection order, which keeps a perpetrator away from the person they're victimizing. So that is one tool that we use a lot in our unit. So otherwise the police, they collect information, they collect statements, they pass those to the Crown Council. The Crown Council are the ones that make decisions around charges, not the police. So they approve whatever charges they see as applicable. And then there's a warrant for an arrest put out for the alleged offender. And they are arrested, and they go in front of the judge, and they are generally released with what we call bail conditions. So at this point, the crime is not proven, there's no guilty plea, there's nothing yet, but we do have protective conditions until it makes its way through the criminal court, which can take a long time, months and months and months. So we do have protective conditions in place after that arrest takes place. Yes, sorry. Oh, 10 minutes, oh, thanks. Okay, so I wanted to make a couple of other comments. One is that in cases of intimate partner violence or domestic violence, we have in this province kind of a proactive arrest policy, which means that the person who has been victimized does not get a choice around police sending that information to Crown and Crown approving those charges. So those are in intimate partner violence cases. So we would see some of those with older adults, and they would proceed the same as with any of us. But when it has to do with an adult child and a parent or a grandparent, that person who was victimized has choices. So even though lots of us or siblings or support people want those charges to go ahead, that person who was victimized might say no to the police, I don't want criminal charges. So they have that choice to not proceed in that way. Support services during that time through the criminal justice system would be police-based victim services. There's community-based victim services. There's Victim Link. So those are all here on the decision tree in terms of getting information about what's happening with a So yeah, I'm going to talk for a couple of minutes about our team. So our team is actually a follow-up unit in Vancouver, and we are not actually a referral service from the community. So we receive all of our files from our own police system, through the Vancouver police system, and we follow up on high-risk cases. And we work on power-based crimes only. So what that means is that we work with cases where I can provide, as a counselor, support and safety planning in that difficult relationship, as opposed to a stranger assault or a caregiver relationship. Those are not the files that we take. We take the files where there's a high chance of the person being killed or coming to more harm, more physical harm, and that they're in a relationship with that person who's victimizing them. I do the emotional support and safety planning. My police partner, who's a detective, she does further investigation to support the file through the court system. And if one of my clients, for example, decides they don't want to go through the criminal system, we do support them anyway. So even though they may decide to drop out of that criminal system, my police partner and I provide support services and safety services to them, regardless of the criminal court stuff. So I would say about 70% of my cases are older adults, maybe over the age of 75, anywhere from 75 to 100. And generally the person that's victimizing them is an adult child. Generally that adult child has an addiction. More often than not, that adult child also has some mental health issues. Chances are that adult child has been arrested a number of times, or maybe not, maybe it's the first time, but it's a very high risk case. And about 25% of my cases are intimate partner violence. So that would be just folks who are older. I work very closely with Vancouver Coastal Health because sometimes we're collaborating, we're working on the same situation. And we follow that sometimes for years. So as probably folks who know in the field, that it's a bit different than intimate partner violence in the sense that your relationship with your adult child may never be able to go away completely, right? So we're just navigating that through our whole lifetime, actually. Intimate partner violence, it's oftentimes people do end the relationship eventually, given the right circumstances. Very difficult with an adult child, and especially one that's very dangerous. So challenges or gaps in providing services for my clients. So what I would say, and I see, and this is just in my little bubble where I work, is that housing for adult children, like so housing for folks with mental health issues, with addictions, I would put my money on every parent I work with would not be living with their violent and addicted and mentally ill older child. The child could be 40 or 50 years old now, if there was adequate housing for them. Not a single one would choose to continue living with them, so that's a big issue for us. And that when they do choose to have them arrested and removed, that they need to be ready for pretty bad consequences. That person will become homeless. They may commit suicide, they can die. It's not an exaggeration that happens, so that parent has to be ready for that because there isn't adequate housing. And the other gap, I would say, is just around outreach services. That I have the luxury of being able to visit clients in their homes, and I feel that kind of outreach service is really necessary, at least with the clients I work with, so some older adults. And I think that's all. I think I covered. I'll just check quickly. Yeah, I think that's all for now.
Thank you, Bonnie.
Thanks.
I'm going to ask Sarah now to talk. Thank you, Sarah.
So my name, again, is Sarah Khan, and I'm one of the lawyers who works here at Seniors First BC. We have, you met earlier, our Executive Director, Berta Lopera, who's also a lawyer at Seniors First, and we have another lawyer named Gordon Marshall, who works as part of our team. We also have right now a part-time volunteer lawyer, which is great for us. So I want to start off just by talking about the program, the Elder Law Clinic program that we provide at Seniors First. So we have, through our Elder Law Clinic program, we offer 7 monthly in-person legal consultation clinics throughout the Lower Mainland. So we have 2 clinics in Vancouver, we have one in Burnaby, Surrey, New Westminster, North Vancouver, and a couple of months ago we added Richmond to the list. And one of the clinics that we offer is specifically for trial preparation to assist seniors who are involved in legal cases or want to start legal cases in the BC Provincial Court or BC Supreme Court, and we can assist seniors with those cases to prepare them and sometimes to review documents and prepare other documents that they might need. We have the information is available on the Seniors First website, but for booking appointments at the clinic, we ask that people call 604-336-5653. We also provide legal consultations over the phone province-wide to seniors province-wide. And so in order to speak with one of our lawyers over the phone, what we ask is that people contact the Seniors Abuse and Information Line for the intake for the person, and then those calls are transferred once the legal issues are identified and all the names are gathered for conflicts check purposes. Then those calls are referred through to the lawyers. The Elder Law Clinic program is targeted at older adults who are 60 plus, 60 years old and over, who can't afford to hire a lawyer. But we also provide legal consultations to people who care about seniors. So we routinely provide some legal options and consultations to service providers. Like I know many of you who are attending this webinar are service providers. So you are also able to contact our line and try to get some, and we might be able to help with some legal assistance. I wanted to talk a bit about some of the legal issues that lawyers through the Elder Law Clinic program can assist with. So for example, we can help with advanced planning instruments such as simple wills, powers of attorney, representation agreements. We can also assist with, we may be able to assist with BC Supreme Court and small claims court cases that don't involve family or criminal law. So long as we have the time and expertise. For example, we may be able to assist with cases involving debt collection or declarations of interest in property. We can provide advice also on elder abuse, including physical, emotional, and financial abuse. Patients' Property Act committeeships are another area where we may be able to assist with. Issues involving the Adult Guardianship Act, human rights complaints, and also advocating for better care in residential care facilities. This isn't an exhaustive list of the things that we can provide legal assistance on, but so if in doubt, please either you as service providers can contact the Seniors Abuse and Information Line for a referral over to our legal program. And that way, or you can have your clients call directly. And then the calls will get put through to one of our lawyers and we try to return calls within a few days. Sometimes, depending on staffing, it might take a little longer, but generally we aim to call back within a few days. Some of the legal services that we can provide include having a meeting with one of our lawyers, receiving summary advice either in person or over the phone. Obviously, for clients who are outside of the Lower Mainland, it's difficult for us to have in-person meetings. We have we have a very small budget for travel and disbursements, so we provide most of the services over the phone. We can also provide some unbundled services, such as drafting of documents. So in other words, we may not be able to represent the senior throughout the legal proceeding, but we might be able to provide services such as reviewing the notice of claim that they may have drafted, or helping to prepare some affidavits. So different things like that. On occasion, we are able to provide full legal representation to seniors, and then we can also, of course, help seniors to connect with other useful community resources. And so then the next topic that I'd like to talk about are some examples of non-criminal forms of abuse of adults who are still capable. They may be in a state of mental decline, but they're still capable. And so Marnie Stickley had already talked about some of the criminal forms of abuse. So I'm going to talk about the non-criminal forms of abuse. I wanted to give you a few examples of some cases of some types of issues that come up on a pretty regular basis for our lawyers. So for example, a person who is given a power of attorney, which is essentially the ability to make legal and financial decisions for the adult. So a person who's been given a power of attorney by an older adult can abuse that power of attorney and do things such as steal money from the older adult, from their bank account, or steal their possessions. Often this is done under the radar of the older adult. So for example, the person acting as the attorney takes out money from the older adult's bank account to give to the senior, and then keeps some of the money themselves, siphoning off significant amounts of money over time and making the theft difficult to trace. And as Marnie was talking about earlier, those can be difficult to prosecute for the police and Crown Counsel. So of course, in cases where there could be some evidence, we do suggest regularly that people contact the police to see if a criminal investigation might be in order, so that the older adults and the service providers explore that avenue. But there may also be some civil remedies, and I'll talk about those in a minute. I'll just give you a few other examples of things that can happen. Or cases that we see. It's also common to see adult children pressuring their elderly parents to transfer title to the parents' real estate into the joint tenancy with the adult children, or completely into the children's names, and then the adult children pressure the parents to leave the home. Sometimes they're just told to leave quickly. Sometimes the children are really pressuring them to move into residential care facilities. Sometimes the adult children also pressure their parents to add them to the seniors' bank accounts, and then start taking money from those accounts. So the children, it's as Marnie was also talking about, it's often adult children who are doing this. Those are the types of cases we see regularly. And then the adult children start taking money from those joint accounts. And the adult children can do this without having a power of attorney, because they're listed as a joint account holder with the senior. Parents often feel intimidated by their children's behavior and are afraid to go against their children's wishes, as the children are often helping their parents with some things like grocery shopping, or some household chores, or taking the seniors to medical appointments. Sometimes the adult children or others are also verbally abusing the seniors, calling them names, telling them they're worthless, and physically assaulting them. So again, in those cases, in cases where there's a real risk of harm, or physical harm has happened, then we do refer those people to the police. We also come across cases where someone is living with an older adult without paying rent, and the older adult has asked them to leave, and these so-called guests refuse to leave. Often the seniors are providing these guests with free lodging or food, or sometimes both. Sometimes in exchange for, usually the relationship the relationships that I often see where the the person who's the guest has started off by providing more help to the senior, but over time they become less helpful, more abusive, and so the seniors are contacting us saying they would like to try to get rid of these unwanted guests. So of course, when people call us when we're providing legal assistance to seniors and the people who care about them, our advice obviously has to be case specific after considering all of the applicable circumstances. But there are some general principles, and the first one is the one that Alison Alini referred to at the outset of this webinar, where she said that essentially the same principle, that we need to respect the right of seniors who have the capacity to make decisions that others might not necessarily agree with, or decisions that may not be in the best interest of the seniors, according to the people who are observing the behavior taking place. So seniors may not want to stand up to an abuser because they are worried about being left alone. These are just some of the reasons. The seniors are worried about being left alone or abandoned. They derive some benefit from the abuser, like company sometimes. Sometimes the seniors just want to have somebody around. They're worried that the abuse might escalate, or they're simply not ready to ask the abuser to leave. So there's a whole variety. That's not a non-exhaustive list of reasons. So we can advise older adults how they might be able to bring legal action to recover money taken from them, either by a power of attorney, or just by someone who has no power of attorney and has just been managing to siphon money from the senior. We can also talk to seniors about how the public guardian and trustee might be able to assist with investigations into abuse by powers of attorney, and how older adults might be able to bring applications to recover their share of real estate that might have been taken from them or transferred under duress out of the hands of the older adults into the hands of often their adult children, but it could be other people as well. We can also talk to seniors about techniques to deal with joint bank accounts. So they might have money in a joint bank account with an abuser, and so a simple way of dealing with that might be removing the money from those joint accounts and depositing the money into separate accounts to which the abuser doesn't have access. In the case of unwanted guests who don't have a legal right to be in the senior's home, so and by that I mean they're not on the lease, they're not in the residential tenancy lease, their agreement or lease, they're not listed on title for the home. So in other cases where those people don't have a legal right to be in the senior's home, then we may be able to issue a notice under the Trespass Act to the unwanted guest to have the senior or have the unwanted guest vacate the senior's property. If the senior is being abused by a family member, we also may advise the senior that they could apply to either the BC Supreme Court or to the BC Provincial Court for a protection order under the Family Law Act. And so this, again, Marnie earlier was referencing peace bonds under the criminal code. Peace bonds are very useful because they can apply to anybody, regardless of whether they're a family member or not. But protection orders under the Family Law Act are specifically to deal with abuse by family members. So the definition of family violence, which is what you need to show in order to get a protection order, the definition of family violence under the Family Law Act is quite broad. So in addition to physical and sexual abuse, the Family Law Act definition of family violence includes psychological or emotional abuse of a family member, including intimidation, harassment, coercion, or threats, including threats respecting other people, pets, or property, It also includes unreasonable restrictions on or prevention of a family member's financial or personal autonomy, stalking or following the family member, and intentional damage to property. Further, if seniors are not able to afford a lawyer to apply to court to get a protection order under the Family Law Act, then they might be eligible to get a lawyer through legal aid to assist them to get a protection order, or to apply to court anyways to get a protection order. But we also do provide advice about, in cases like that, we provide advice about the fact that the older adult should also investigate the option of getting a peace bond. So they're not mutually exclusive. We try to provide advice to get both types of potential protection orders. The last thing I wanted to talk about is how you can work with, we have a victim service worker program here at Seniors First BC, and also on the decision tree alluded to earlier, there's a number there for, I believe there's a phone number for Victim Link, which is victim service workers province-wide. But we have a victim service worker here at Seniors First who specializes in victim services for seniors. And so sometimes what we do through when in appropriate cases, when we're working with seniors through the legal programs here at Seniors First, is we sometimes, with the older adult's consent, we might refer that older adult to our internal victim service worker program. So for example, in cases where we're advising the senior to take steps that might cause the abuser to react negatively, if the older adult consents, then we might say, look, we can have our victim services worker give you a call. And our victim service worker can help older adults to create safety plans. So for example, things like changing locks, ensuring that the abuser doesn't have access to communications the senior is having with victim services and lawyers who are involved, and many other things that can be all involved in safety planning. Our victim services worker may also be able to assist the older adult to apply for legal aid in order to apply for the protection orders. And finally, we can also refer people to appropriate people in the community who can assist, such as Victim Link, Transition Houses, Public Guardian and Trustee, Public Guardian and Trustee's Office, the designated agencies from the provincial government's health authority. So there's lots of different options for us to make referrals. And that's what I have to say.
Thank you, Sarah. I'm now going to ask Nagat to speak.
Yes, thank you, Genevieve. I am going to discuss about the residential tenancy issues affecting seniors, and I will take a start from there, that what does constitute a tenancy and what does not constitute a tenancy. Actually, the Tenancy Act applies to tenancy agreements, rental units and other residential properties, which could be BC housing, non-profit housing, market rental units or basement suites. There is like a provision in the Tenancy Act which says that the tenancy agreement must be in writing. However, the residential tenancy branch does admit the relationship between the parties when the rent is paid and the security deposit is paid at the time of move-in. We have to understand that what does not constitute a tenancy. There is a list of those premises and buildings which are not covered under the Residential Tenancy Act, and those are co-op housing, educational institutions, living accommodation which is given to someone for business purposes, vacation or traveling arrangements, and now we hear about Airbnb, which is not covered by Residential Tenancy Act. Any emergency shelters or transition house is not covered by Residential Tenancy Act. assisted living and care facilities are not covered. Public or private hospitals, any mental health act treatment facility, rehabilitation treatment services, and any other like premises which is covered by the Manufactured Home Park Tenancy Act. Last but not the least, when the landlord, who is the owner of the premises, shares the kitchen and bathroom with the tenant. So this is a list which is not covered by the Tenancy Act. There is a new provision in the Residential Tenancy Act which has been introduced recently, and there are a lot of issues around that, and we had seen people, especially older adults, facing those issues when someone who is unauthorized person moves to the unit, and it becomes more complicated for maybe the police department to remove that person to determine whether it is a tenancy issue or it is out of tenancy agreement. So when there is any assignment or the sublet under the act, it says that the original tenant, when the original tenant has not got the permission of a landlord in writing to have someone in the unit, then the person who is there will be an unauthorized person. So this is, I mean, more or less the, I mean, I am not giving the exact like wordings of the section, but if someone moves in and then the original tenant does not get the permission from the landlord in writing, then it becomes an unauthorized person. And then the older adult, like when we deal with that person, then he not getting the permission is vulnerable, and that person is facing the eviction, because when the landlord comes to know that there is an unauthorized person, our client is given with the notice of eviction under section 47 of the Residential Tenancy Act. So we had seen lot of cases where, I mean, the unauthorized person who might be the child of the older adult or might be a stranger who just met with the older adult, and then he comes in as a guest and stays there for unlimited period of time. I am going to discuss here about some of the other provisions of the Tenancy Act to see that whether there is any neglect and abuse between the parties, like as a tenant or as a landlord. So interestingly, the Tenancy Act does not give the express definition of abuse and neglect. We had seen the whole act regulation, and there is no express provision there. However, when the rights are violated, it could be either the tenant or the landlord, and when it is a tenant, we say that, okay, loss of quiet enjoyment. So it is a simple phrase, loss of quiet enjoyment, but there is a list of like incident which we can add into, including the abuse from the landlord, any kind of abuse when he enters, like the landlord, when he enters in the unit without giving the prior notice in writing and does not state the reasons of entering. So this is abuse. When the landlord has failed to maintain the property as per the health standards and has not complied with the act. Of course, I mean, this is a loss of quiet enjoyment, but also a neglect at the part of a landlord. So these are the examples which I can quote here, that how the act gives the explains the different things, but does not expressly define the abuse and neglect. If there is anything where there is any illegal activity going on the premises, and it is multi-dwelling building and one tenant is being affected and the landlord is not taking action, then we have to maybe refer our clients to two different places, send a letter to the landlord, but also contact the local police if in case that you can see that what help you can get from the local police. Then, I mean, in this way, we help our clients and see that what is going on. And I mean, in case the issue is not resolved, I will say that we ask our clients in Seniors First PC that the tenant can decide to move out from the rental unit if in case that the landlord has failed to comply with the act. So it is a statement which I am giving, but we have to speak with our clients in details that what will happen when he moves out, if it is a fixed term tenancy, what will be the repercussions. So we give an extensive advice in that case. And then there are provisions that a tenant decide to move out and then has to give a notice to move out if the landlord has not complied with the act or has failed to correct that harm or that situation in a reasonable period of time. In that case, we talk to our clients, provide advice, and see that whether it is a month-to-month tenancy or whether it is a fixed term tenancy. And based on that, we help our clients maybe giving a notice to move out from the rental unit. Here I am going to give you some situations where, as a legal advocate, I dealt with situations when it was difficult for the local police to remove the unauthorized person from the rental unit. Though I recognize that, as Marnie said, that the police has helped clients or older adults in removing the unauthorized person from the units. But when someone who is living there for maybe from last couple of months, then it is uncertain whether the person is a co-tenant, whether the person is a subtenant. So there are different definitions which the Act describes who is a co-tenant and who is a subtenant. As I said before, that when the original tenant does not get the permission in writing from the landlord and keeps a person, that is an unauthorized person. So we had seen cases when our client, older adult, was an acquaintance with someone. He brought a person to the unit because that person was in stress, became homeless, and that person was evicted previously. Our client met that person somewhere, brought that person into the unit as a guest for maybe 3 to 4 days living there. It ended up that the person lived there for 1.5 years. Though our client, older adult, tried his best or her best to remove that person, but he was unsuccessful. In that case, the landlord came to know about a situation that there is an unauthorized person, and the landlord gave a notice of eviction to our client, to older adult, and then he was facing eviction. What happened actually, our client, he contacted at Senior Abuse and Information Line, and then it was referred to legal advocacy program. The step which I took is to challenge the notice of eviction was my priority, to keep it within the limitation period so we can do the rest of the work later on to determine about the unauthorized person and getting or seeking the help of the local police. So we filed a dispute resolution application. After filing the dispute resolution, we got a date, which is always maybe in a 1 month period, to be scheduled for hearing. The very next day, I called my client, and then we had a lengthy conversation in our office, in which I interviewed him and asked a few questions, and I can share that what were the question on my list which I asked my client. And then I will say that in case that the police is facing such kind of a situation, they can use those one if there is like a situation when the person is unauthorized. So this is not the like exhaustive list, but I can share what I asked. So my client, I asked him, so when did the abuser move to the unit? Did the older adult got the permission from the landlord in writing? Whether the abuser was paying rent to the older adult or to the original landlord? Whether there is a common law relationship between older adult and the abuser, whether there is any intimate relationship between the parties. The police can contact with the landlord to get more information. Whether the landlord has issued a notice of eviction to older adult for keeping an unauthorized person in the unit, and the older adult is at the risk of becoming homeless. The scale of risk to the safety of older adult and how vulnerable the older adult would be if the abuser stays there. And in my client situation, the abuser pointed a knife maybe 3 to 4 times and threatened to set the house on fire. The physical health of the older adult and the other person, like my client was 83 years old, on wheelchair, disabled, and the other person was maybe in late 30. So these are the factors which I considered, and then what I did after that, from our office we called the VPD and we confirmed this situation. Then VPD took action and removed that unauthorized person from the unit. I will say that this is something that in each situation is unique. I cannot say that all the time the person could be removed, but it depends on situation to situation. If the local police is unable to determine or ascertain that it comes within the Residential Tenancy Act and they cannot remove the person, then they could refer the older adult to Senior Abuse and Information Line to seek more advice. We can help the client seeking an order from the Residential Tenancy Branch, which could be a very quick hearing, could be scheduled. Like I talked to Residential Tenancy Branch and they said that they could schedule the hearing on urgent basis, and then could determine that whether it is a tenancy issue, and if it comes within the Residential Tenancy Act, then it will go to arbitration. If not, the adjudicator can give an order that it is not covered by Residential Tenancy Act, and then we can present the order of Residential Tenancy Branch to the local police, and then the person could be removed from the unit. One more thing which I want to add here, that we coordinate among ourselves in Seniors First BC in a way that if there is a file pending with me as in a legal advocacy program, and there is like the client is facing some other issues which could be referred to victim services program or to elder law clinic, then we have internal referral system. Our files are totally confidential. The information which we have in our files, we don't share that one, but we refer to the right person, and that's it. We work here. So thank you very much.
Thank you very much. Thank you, Nagat. I'm now going to hand it over to Alison.
Great, thank you very much. I've been madly taking notes from all the comments from my esteemed colleagues here. Thank you for all your comments. So I'm going to speak about the role of the public guardian and trustee, and just going back to the decision tree for a moment. This is the part of the decision tree, the bottom third of the page, where the answer to that question, can the adult seek assistance, there's some doubt, at least some doubt, or a belief that no, the adult cannot seek assistance on their own. So that's the context for what I'm going to speak about now. So as we've heard very eloquently from Berta and her staff and Marnie, we know that there are many adults in BC that are experiencing abuse, neglect, and self-neglect, and the vast majority of them are mentally capable. And so, you know, we've talked about what that means for them and for us as people who care about them. In terms of the public guardian and trustees role, we investigate about 1,500 situations annually where there are concerns about abuse, neglect, and self-neglect of adults who may be mentally incapable. And just to give you a bit of a picture of some of these situations, so it may be someone who, as we're all living older, someone who is, getting on in years, maybe they've outlived a lot of their supporters, and they've managed very well throughout their lives all along. But something's happening, maybe there's a dementia, and they're just starting to neglect their own finances, just no longer able to take care of that, stay on top of the mail. And as we all know, finances are becoming more and more complicated, more and more technology involved. So it could be a situation of self-neglect of finances. We also get in these 1,500 referrals a year, situations where there is a concern about someone who is being financially abused through joint accounts perhaps, or threatening to sell the adult's property, and there's concerns that the adult is mentally incapable and not able to think through what to do about that. And there are also some occasions where we get reports because the adult has actually done some planning ahead. They have an attorney under a power of attorney, a rep agreement under a rep agreement, or sometimes even a committee, where that person who's supposed to be acting in the adult's best interests may not be doing that for whatever reason. And sometimes that is really about not understanding the role as a substitute. I don't know how many of us recall someone saying, hey, I just got a text from someone lately saying, hey, if it doesn't work out that both my kids can act, would you be my, would you take action under my will, and would you be my attorney, and would you be my representative? So, I mean, we do get asked these things, right? And we don't, because we care about people, might say sure without really understanding all the implications of that. And so I think sometimes people just don't know what their duties are, and I think also sometimes people have their own personal things happening where they're under pressure, and a lot of some of the things going on that Marnie talked about that complicate situations for people. So we get a vast array, this kind of variety of calls. Under the Public Guardian and Trustee Act, the Public Guardian and Trustee has a really important role to protect the legal and financial and sometimes personal and healthcare interests of adults in vulnerable circumstances who require assistance with decision making. The department that actually looks into these situations is our Assessment and Investigations department. It's part of Services to Adults. And the staff who do the investigations of these kinds of situations are regional consultants. So for the regional consultants to look more deeply into a situation, there are 3 criteria that determine whether they can conduct an investigation. One is there has to be a reason to believe the adult may not be mentally capable. So that doesn't mean that there's a formal assessment in place, but there has to be a reason to believe there's a concern about the adult's functioning and cognition. We also need to know that the adult's finances and assets are at risk, and also that at least at the point of a referral, that there is no one apparently available who can assist the adult. And remember, we're looking at this in terms of what can we offer that is least intrusive, most effective, right? So that really is the underlying ground of an investigation. We get our referrals from financial institutions, from health authorities, service providers, care homes, landlords, neighbors, families, friends, and on occasion, the adult themselves. So yeah, I mentioned the staff really working at this day-to-day. The bread and butter of their work is really trying to balance autonomy and protection, and what is the balance that's needed there. Some of the things that our regional consultants can do in doing an investigation or considering to begin one, Depending on the details that are presented to them, they can consult on complex cases where there are concerns about anyone who might be experiencing harm or causing harm to an adult in vulnerable circumstances. We can do investigations of people that might be accessing the adult's money, including people who, as I mentioned, may have a legal authority, like they may be an attorney under a power of attorney or a rep under a rep agreement, trustee, committee. We can, the staff can use what we call protective measures, and those involve being able to temporarily protect the funds in the adult's bank accounts, or protecting preventing property transfers during an investigation. The protective measures can be put in place for up to 30 days and renewable up to 3 times for a total of 120 days. And the staff can also request an accounting of how the adult's funds are being spent if there is someone responsible for managing the funds. And we also work very closely, as I mentioned, with that two-way arrow in the bottom right-hand corner of the decision tree, work very closely with designated agency staff, who you'll be hearing a lot more about from Leanne, because we know that abuse of a financial nature may not be occurring on its own, that there's probably a emotional component, and there could be a physical safety component. So when the regional consultants receive reports, there's a number of things that they can do. They gather information. So depending on the information that they're provided with initially, they can gather information from the adult and people in their lives, if that seems appropriate. They can obtain reports about the adult's health, personal, legal, or financial affairs. They can get information from the adult's financial institution, physician, landlord, lawyers. And one of the things that the PGT does in our working relationship with designated agencies is if more detailed financial records are needed, we have a clearer ability to access those if there's any difficulty obtaining them at certain points in time. We can also ask substitutes, as I mentioned, to report on how they've been managing the adult's money. So these are the kinds of things that happen during an investigation, and I guess I just want to reinforce that just because there's a referral to the public guardian and trustee does not necessarily mean that we are going to become committee of estate. That is the end of the road, where we've tried and looked for all kinds of other options, and there aren't any for whatever reason. So what are the things that we do that might happen so that we don't end up in that role or recommending someone else become committee? So we recommend informal solutions. So for people who don't have a lot of financial resource, it may be that direct deposits will resolve some of these things. We make referrals to organizations like the Bloom Group if someone only has pension, federal government pension income. We may be able to make the right referrals to community agencies that can provide just enough support in keeping with that least intrusive, most effective, just enough support principle. And then I guess if those things are not enough, then what else can we do? I think I might have mixed up my pages because I was so busy taking notes. So investigations, so when we're doing all those things, some of the outcomes that may be that those informal approaches have worked. It may be that the adult is still mentally capable enough to be able to make an enduring power of attorney or a Section 7 rep agreement. And so maybe sometimes when investigations are underway, people do turn up in the adult's life that maybe haven't been involved for a while, and may be very willing and very appropriate people to assist. So people may come to light. It may be that if there has been a substitute decision maker in place, it may be that they didn't understand their duties, but they do now, and they can, follow the duties outlined in the legislation. Or it may be that if the adult can't make an enduring power of attorney or a rep agreement, there is someone who is closer to them, certainly, than we are, that can apply to the court to become comity of estate. So there's lots of things that we're looking for before proceeding down the path of becoming comity of estate ourselves, which is, sort of the end point. So for some people, that more formal resolution is the only solution, the best answer. And in that situation, being named comity of estate, either through a certificate or court order, the PGT is responsible for all aspects of the adult's financial decision making. And we do that in another department, so client services, and the service of making those decisions for and with the adult are made by case managers with a team of financial professionals who work with them. And I guess the other thing I wanted to say as well is that, when the public guardian and trustee is comity of estate, we have the same responsibilities as other comities to foster the adult's independence and involvement in decision making. So I think that's a really important piece to add. And I'm done. Thank you.
Thank you very much. So now I'm going to ask Leanne to speak.
Okay, thank you. I am going to discuss the role of the designated agency. So we have a piece of legislation in British Columbia called the Adult Guardianship Act, and in February it'll be 19 years that we've had the piece of legislation, which is relatively young for legislation. It is something that we are learning new things. I'm learning new things every day about the legislation as we use it and test it, and also it's very much an evolving practice. So in basic terms, it's a piece of legislation that allows us to provide support and assistance and protection to adults who may be vulnerable. And the term vulnerable, although it's not actually in the legislation, it speaks to people who may be unable to get help on their own because perhaps they're being physically restrained. They may also have a physical disability or illness that prevents them from physically getting help. And what we do come across most often is an illness, disease, or condition that affects their ability to get help. And that may look like a mental illness, an acquired brain injury that could be from a medical event such as a stroke or a car accident. It could be the result of long-term substance use, drug or alcohol, that actually changes the person's brain and the way it works. Or some people with developmental disabilities that are born with challenges, fetal alcohol syndrome, or even people on the autism spectrum. So there's a range of people that may be more vulnerable because of their condition or physical state that this legislation is meant to support. So I'm sure everyone's familiar with child protection legislation. We have the Ministry of Children and Families in British Columbia. We have mandatory reporting for child abuse. This is the designated agency role. The Adult Guardianship Act is it is adult protection. We do not have mandatory reporting for adult abuse and neglect in British Columbia like we do for children. However, a lot of the agencies, for example, where I work, which is Fraser Health, there's an expectation that if our staff come across a situation like this in the course of providing service or care to people, they do make a report. So our expectation is for our staff to bring it forward, even though there's no mandatory reporting in British Columbia. So basically the legislation provides us the mandate to receive reports, conduct investigations, determine, as Allison said, just how much support or assistance a person might need, whether they actually meet the criteria of the legislation. Sometimes we need to become more intrusive in people's lives depending on what their situation is and the amount of risk that they're at. And that can look a lot of different ways. We've talked about a few across the panel. So we do conduct investigations. We receive reports. People can make reports to Fraser Health through many, many ways, coming into the hospital, self-disclosure, family member, bringing forward a concern through our points of access throughout the system. And that is our report. We conduct investigations, and then we determine if the person meets the criteria of our act. And if they do, we can offer a suite of services. If they don't, we can still offer them a suite of services. And if they choose not to accept it, that's their choice. So we have within our system a system of staff who are called designated responders. So in the course of doing their work, so for example, you're the social worker in the emergency department of the hospital, you've also been trained to respond and conduct investigations under the Adult Guardianship Act or our community programs, home health, mental health, those working in residential care. We also have a system. Those people receive reports and conduct the investigations. I really see the Adult Guardianship Act as a continuum. So, I mean, on kind of the less intrusive end of it, we have a mandate to respond. So that actually gives us the opportunity to look into the situation. We gather collateral information from as many sources as we can that make sense. We also interview the adult. And easier said than done in some situations. And that's why we have some other tools in the Act to help us access people who, if we're having a challenge, actually sitting down with them in a safe way to get their perspective on their situation. So the legislation allows us to kind of open up the investigation, start gathering information, meet the adult, talk to other people in the person's life, if they're willing to speak to us, to try and figure out what's actually going on. We get lots of reports, and some are substantiated and some are not substantiated. So in our investigation, we're asking and answering two questions. So is there abuse, neglect, or self-neglect? Is it actually happening? Because unfortunately, we do get some reports that people are making reports to us for other reasons, not necessarily in the best interest of the adult. So we need to kind of weave through that. And then the other question we need to ask and answer ourselves, is the person actually able to get help on their own? And as a few of you have already mentioned, capable people have the right to make their decisions and live at risk. And as you say, sometimes that is hard to watch, especially for neighbors and family members who care about a person. It is very difficult. But we will look to see in our interviews with people, we may do some cognitive screening with them to understand, how's their memory? Are they oriented? Are they unwell due to a medical condition? And we also will kind of look at their executive decision making to see, because what we know is in order to get help for yourself, you need to be able to initiate, plan, and follow through like we do on all our decisions. And sometimes, depending on people's conditions, they may have not have that ability anymore. So it's really important. So we take all the information together to determine, do we have a role, and what role might that be? So there's a variety of, I would say 80% of the cases that come across are into our program that we actually have substantiated abuse or neglect and the person isn't able to get help. Our approach is really providing support and assistance to the person. And so the great news is we have a lot of assistance within the healthcare system that we can actually provide to people already. So it's not anything special that we don't have, but sometimes people aren't even aware of what's around. So there's home support that can come in and help support people. If we have perhaps a caregiver that is neglecting the person, we can take some of those tasks off their shoulders to maybe kind of change the relationship, so decrease the dependency. We can look for financial options like through the public trustee or the Bloom Group or other family members. We get people to attend day programs, so they're kind of out of the house a few days or once or twice a week to provide respite and support to a caregiver. Medication management is huge. We work with our staff, home support workers, or private pharmacies to come in and actually dispense medication. Sometimes people don't want to take medication from family members, right? It's hard. So if we kind of take that, that is something that we have great success with. Sometimes it's not a safe place for the person to live. We need to look at other options through assisted living, or sometimes very high care people need residential care. Medical equipment. Sometimes the issue is the people they need a hospital bed or a lift or things to a wheelchair or things like that we can have assessments done and assist people to get the access to medical equipment that will keep them safer at home. And sometimes if you have a family member who's physically transferring someone back and forth and hurting their back, or the person's up all night, there's a lot of things that we can do to try and support care. So mostly what we do is we put in support and we access, primarily in our designated agency, it's registered nurses and social workers and they have a magic way around. And so they're not here to blame or point fingers. They're approaching the situation as a family situation and trying to offer support and recognize we have family members as caregivers who are doing a tremendous job, and it's a 24/7 job, and sometimes we need to just acknowledge that and keep trying to support people so we can actually keep everyone healthy in the relationship. So there are situations as we go to the middle of the continuum that when we get a report about someone who's living in their home in the community, and our staff, our social workers and nurses will go out and we'll phone or we'll knock at the door, and people generally will let us in. There's the odd time that people will not let us in, either the adult themselves or someone else who's living in the environment who has perhaps a vested interest in the status quo, and they will deny access. And so we do have provincial court tools to get an entry warrant or an access order to try and get ourselves behind the door, because again, we need to interview the adult. That's our last resort. We would definitely try everything else. Sometimes we even try and work with people to attend their family physician's office to get in and interview them in a safe place in the examining room. So we have lots of little tips and tricks and things that we try. And then we can get a restraining order for up to 90 days while we do our investigation. We've never done that in Fraser Health, but the other health authorities, I know they have done that. And we kind of shift over down the end of the continuum, which, as we know, court is the last resort, and we don't go to court very often, only in rare high-risk situations. And there are the ability to actually get basically a care plan, a support assistance care plan, court-ordered by a judge for people to accept. Or we also have another very on the intrusive end is the ability to provide emergency assistance to people, basically kind of trying to prevent what Marnie mentioned, kind of life or death situations. We may need to enter and remove a person and get them to a safe place and protect them for a short time while we're able to actually determine what their ongoing needs are. So that's kind of the continuum of what we do under the Adult Guardianship Act. We have hundreds of examples, unfortunately. But we did have a very, I think for me to be able to come to work every day and do this very challenging work, you know, you have to be passionate about it. And so we had an excellent case a few years ago with a woman who was 84 years old. We got a report that her family were not being able to access her. She was very involved with her religious community, religious and cultural. They weren't being able to access her. She had gone and had a hip fracture and came back from another health authority in Vancouver with recommendations for equipment and support, physiotherapy denied. So all these things kind of were lining up to be very concerned. So we went out to try and meet with her, and of course couldn't get in. Went out a couple times, called. She lived with her son, just one son. And went out with the police, again, couldn't get in. And then we felt that we couldn't actually access her to find out tell her, the concerns, find out what her perspective on. So we actually, and this is the one and only time we've done this in 19 years, is we applied for an access order under the Adult Guardianship Act, which means going to provincial court, serving people. The adult and her son arrived, which was great, came to court. It's always half the battle. And we were able to express our concerns to the judge. They expressed their concern. The son, interestingly, didn't have her hearing aids in, so perhaps she wouldn't be able to hear. A lot of things, pulled it out of a little plastic bag. Anyways, they wanted, was okay with people coming in to see his mom as long as it was videotaped. Again, in the context of abuse, not a good idea. So anyways, the ultimate end of the day, we did get this court order that allowed us to go in and have the police remove him, keep him outside while we did our investigation. So we had one of our social workers from our mental health team who went in, and she spent almost 2 hours building rapport and talking to this lady and trying to, figure out what her perspective was. And the tipping point was when she actually told her that her loved ones were trying to access her and they couldn't. And all of a sudden it was like, because she didn't know. She was being basically kept prisoner. She was stripped of her religion. She was switched over to, probably on the religious continuum, the opposite end. She had her money taken from her. She was being physically abused and emotionally abused by her son. She did not even know, because she had been told all these things that no one loves you, no one's around, no one cares. So of course she felt she had no options. When our social worker actually said, no, she's like, and she wanted to leave. Now, at that point, she did not meet the criteria of the Adult Guardianship Act. Once she had the information and the opportunity to process it and make a decision, she said, I want to leave. We supported, we got an ambulance, we took her out of there right away. But it was only before we actually got behind the door and interviewed her were we actually able to make a decision. And the great news is she didn't meet the criteria of the Adult Guardianship Act, but we needed to use the tools to get behind that to determine, because we never know until we actually sit down and meet with the person. She left. She was reunited with her family. They took her to a safe location. She had time to kind of get out of the situation, and then she made a report to the police, and the son actually had 4 criminal charges against him, physical. So he had taken all her money, and she was just being really held prisoner in her home, which was a nice home in a nice community that you wouldn't know anything that was going on. So great outcome for us. And a great outcome for her. So to me, that's the value of the Adult Guardianship Act, right? You never know, life-changing. So that's why I come to work every day. So, do I have time for one more, or am I done? Okay. Okay, that's fine.
Thank you very much.
You're welcome.
Okay, thank you very much to the panel for sharing all of that information. We're going to open the floor to questions, and I'm going to just have Paul just chat about how to go about that.
Good day. This is the host for the seminar. Online persons, if you wish to post a question, please put it into the chat window, and I will relay the question to the room. We currently have 3 comment questions, if you're willing to go for that now.
Yeah, go ahead.
Okay. First one is addressed to Leanne. The questioner works in Vancouver Coastal Health, and she understands that you work at Fraser Health. So she's curious if you have representatives similar to you in the other health authorities, if you happen to know who they are or the referral points.
So yes, so designated agencies in British Columbia are Community Living BC for adults who are eligible for their services. Then all the other health authorities plus Providence Healthcare. So each, because we function independently, each health authority has its own structure. There is a person like me in each health authority, and there is a list on the Public Guardian and Trustee website, I believe, that directs people to the proper phone numbers and access points.
And if I could add, you can also call the SAIL line, Seniors Abuse and Information line, and we can provide that information.
Okay. There's another brief question. Is there a safety plan for seniors that can be shared with victim services? I don't know if it was addressed to.
Okay.
Yeah, so there's lots and lots of different safety plans. Yeah, I don't personally use one particular tool, but yeah, I can certainly provide some guidance for doing that. I mean, that if you want, this is from a victim service provider, I think, is that correct? Victim
I'm
services?
guessing that's what it is.
Yeah.
Okay, there's a comment here. This person appreciates the presenters' real experiences and frankness in their presentations. Valuable examples for this person who's doing presentations related to elder abuse, saying thank you.
Thank you very much. That's good.
And there's been another one come in. Actually, that was the same person. If a client has severe dementia and discloses physical abuse, are the SMP able to conduct an investigation given the cognitive deficits?
Yes. Yeah, absolutely.
That's
Police should be called and an investigation should be done. There's other evidence that can be collected, yeah, and make sure also that the person is safe.
That's the end of the
That's the
online
end of
questions at this
questions.
point. Does
Okay.
anyone in the room?
Anybody in the room have a question? Do the panel have questions for each other or comments?
Can I just add one thing I forgot to say?
Okay, sure.
So one of the really important protections, I think, in the adult guardianship legislation is that anyone who makes a report of abuse, neglect, or self-neglect, either to the public guardian and trustee or the designated agency, we are required to keep the name of the reporter confidential. And the reason for that is to enable people to come forward when they are concerned about someone without fear of, repercussions. And that is something that I forgot to say.
Okay. Good. If there are no more questions, then I think we'll conclude the presentation. If you do think of any other questions, you can email them to me and I can direct them to whoever can answer that question. And I have sent emails to everybody, so you would have my email address. And so that's it. And thank you very much to everybody. And thank you, Paul. And that's it.
Thanks, everyone.